as we go along here. So what we're going to do is I'm going to give you just a quick overview of what happened during the session and where we are in the session. We're going to, excuse me, we're going to shift then and hear a little bit about some of the bills that we worked on. One that concerns visitation in hospitals for people with disabilities, supported decision-making. We'll talk about some of the many mental health bills, bills relating to the Children's Services Act. We'll talk about some ongoing work groups and studies. And then we want to wrap up the time together by talking about 3 of the bills that we were actively working on and that all had really good success. I think we can go ahead and have questions as we go through all of this. But if you would, if you've got a question, raise your Zoom hand like we just did during the poll, or put the question in chat. And Courtney's going to be monitoring those 2 things for us, and she will interrupt us from time to time when there are questions or raised hands. So that way we'll be able to make sure that we get everything covered in the time that we've got to share with you today. The 2021 session ended around March 1. That was actually the 2021 session part 2 because of some weird games playing that was going on where the Republican Party refused to cooperate with the Democrats in extending the session to an additional 15 days, as typically happens. So the session ended at 30 days. All the bills were continued until the 2021 special session, part 1. And it is that special session that ended officially on March 1st. So we're now approaching on Wednesday, this coming Wednesday, what is called the Reconvene Session. And that is when the legislature comes back together to consider any kind of changes that the governor might make to bills, has the opportunity to override any kind of vetoes that the governor has, and then debate any changes that the governor has recommended for the budget. This year, perhaps to no one's surprise, the governor did not veto any bills at all. Did not veto, certainly didn't veto any of the bills that we worked on, did not veto any bills at all, but did make some recommended changes to some bills. And there's one of them that concerns mental health issues that we'll talk about a little bit. And of course, made some recommended changes to the budget. So the General Assembly will reconvene on Wednesday at noon, and we'll begin to debate the recommendations from the governor, and we'll make decisions about whether to accept his recommendations or not. So if you're interested in going into greater detail on any of the things that we're going to cover today, you can find them on our website. You can find greater detail on our website under a section that we call Legislative Highlights. Reports are called Our View of the Legislature. They're on our website, and they give you some greater detail on pretty much all of the bills we're going to talk about today. As most of these bills have now reached their final form and have actually been signed into law already, we will do wrap-up reports on all of them so that you have the final word on all of these things. The only thing that's not final yet will be our report on mental health bills, because there are some changes that the governor is recommending on one of those bills. So let's go ahead and hear from Jenny and hear about the bill you worked on concerning visitation in hospitals.
Hi, I think I know most of you, but in case I don't, my name is Jenny Skatine. I'm a disability rights advocate with dLCV, working in the children's unit. I had the opportunity to work with Delegate Tran to advance legislation allowing individuals with disabilities to have a support person of their choosing with them at the hospital. And so this had already existed as a provision during the COVID pandemic. But we really wanted to ensure that this was possible for people post-pandemic as well. We had really broad support from the disability community too. So many people were active in this legislation trying to get it to pass because it really allows people with disabilities in Virginia to receive and advocate for appropriate care. And I'm happy to report that it passed unanimously, yay! And it'll go into effect in July. So even though the current provisions are still in effect for people let's say that COVID, let's hope, disappears or, really dramatically decreases in the summer, and the protections that were afforded during that time to our constituents are removed, this will still be there. So it was a really exciting piece, I think, to work on that really has broad implications for our constituency. Any questions?
It was really great work. And this has been a long-standing problem for people with disabilities who sometimes have a much harder time understanding what's going on in hospital settings and rely upon their regular caretakers or their family members or somebody really close to them to help them understand what is happening. So the pandemic gave us the opportunity to really kind of like make the point about how important it was to have friends there. But this is going to be legislation that will live past the pandemic as well. So congratulations, Jenny. Congratulations, Delegate Tran.
Thank you.
Any questions for Jenny? Courtney, are we seeing anything?
No.
Okay. All right. Well, Rhonda, tell us what happened with supported decision-making.
Yeah, thanks. So this session, Delegate Rob Bell introduced House Bill 2230, which is a bill that would require the Department of Behavioral Health and Developmental Services to create an education program to educate people with intellectual and developmental disabilities, their families, and members of the service provider community on supported decision-making and how it works. And there was also a budget amendment that was introduced that would provide DBHDS with funding to hire a staff member to implement this education program. It did pass. There was a little bit of discussion from some parties that were opposed, but there was a lot of support from well, of course, dLCV, also other advocates for folks with disabilities, the ARC of Virginia, some other advocacy organizations spoke in support of the bill. And actually, I was able to use the work of one of our advocates, Michael Gray, who's on the phone with us today, who worked with a young woman who had a guardian that was very uninvolved with her life and almost resulted in a serious medical outcome for her. And so the members of the subcommittee that were considering the bill when it was initially referred to the House Committee on Health, Welfare, and Institutions were pretty incensed about what they heard about that. And so, the point that we were making was that, even although supported decision-making is a great addition to our compendium of policy that gives people their voice and choice and enables self-determination, it can also be life-saving for people. So this was one of those situations, and the bill did pass. The budget amendment was approved by the General Assembly. So hopefully within the next 6 months or so, we'll see DBHDS coming up with some educational materials for the community on this important issue. So.
Excellent. Any questions for Rhonda about that? So let me tell you a little bit about some of the mental health bills that were in play this year, and one of them that had some amendment to it. There are really a number of bills. None of them, it was not as controversial a mental health year as it is sometimes. The bills that came out of what's called the Deeds Commission, or the SJ47, it's basically a behavioral health legislative committee, had been ones that we had been working on, things that we had seen coming, and that we were able to have some influence on as they were being developed. The biggest one that came out of that group and that was ultimately passed concerned what's called mandatory outpatient treatment. It is a process that exists in code where somebody who's in a mental health crisis can be ordered to receive treatment either after they've been hospitalized or in lieu of being hospitalized. And it's a process that consumers with mental health issues really tend to not like very much because of the forced nature of it. And we all know that people who are forced into treatment are much less likely to stay with that course of treatment in the long run. So we advocate for use of mandatory outpatient treatment only in the most dire of situations. This bill from Delegate Hope, it was House Bill 2166, made some changes to the existing process for mandatory outpatient treatment, and some of the changes were good. It did require the courts to consider a person's advance directive or directions or wishes that they may have stated in some other ways, and made it clear that courts are supposed to consider things like what the impact of this treatment will be on someone's job or someone's school, or their life outside of forced treatment. It did order the it did change the default length of the order from 90 days to 180 days, which is an amazing amount of time when you think about it. It's a half a year that somebody would be in this mode of forced treatment. And we did oppose that lengthening, and we were not successful in our opposition, but we did get some instruction in there that the courts have to think about whether that 180 days means somebody will lose their job, means that somebody will get thrown out of school. It also removed something in the law right now that says that the individual has to agree to the treatment, and changed that to be that the individual has to be able to comply with the treatment. And it may seem like kind of a fine line, but there is a difference between agreeing to the treatment that is being forced on you and whether you're able to comply with that. And so we are concerned about how that's going to develop as it's being implemented. One of the good things about these changes is that Delegate Hope put a delayed enactment date on it. It will not be in effect in July of 21, as other bills will be. It won't be in effect until 2022. So that will give us a little bit of time to really dig down, study the law, and see if there are some other ways that we can get some better protections for people with disabilities in that bill. The bill that the mental health bill that the governor did amend a little bit was a bill that has to do with offering evidence in criminal trials that you have a disability. So it might surprise you to know that if somebody has, if someone's in a criminal court and they've got an intellectual disability or they've got a mental illness, right now under criminal law and under our criminal procedure, you cannot offer any kind of proof of that disability to the court. The bill that was passed this year, HB 2047, would first of all require defense attorneys to get training in these specific disabilities and would allow them to enter evidence of that disability, particularly if the disability could prove that the individual didn't have the intent to commit the crime. There are some crimes where you have to actually plan to commit the crime in order for it to be a crime. And so this would allow defense attorneys to enter evidence of a cognitive impairment, a mental illness, to show that they couldn't possibly have had that intent. So it did pass the House, it did pass the Senate. It was very controversial. There was a lot of disagreement. It was not on party lines, but a lot of disagreement between the House and the Senate about how far this legislation should go. And it did go to the governor. The governor made an amendment to the bill. And so we will be curious to see what happens to it on Wednesday. The bill as it came out of the legislature allows a court to enter a temporary detention order if somebody is found that they could not have had the capacity to commit the crime. And the governor changed that from a temporary detention order to an emergency custody order. It's kind of a fine line there too. What's the difference? We think it's an important one. The emergency custody order is at a much earlier stage of the commitment process than a temporary detention order. But we know that when the bill was being debated by the House and the Senate, that distinction between a TDO and an ECO was one that was a spot of a lot of contention. And so I think advocates are worried that now that the governor has done that, it may cause the entire bill to fail. So we will be curious to watch that as it goes forward. Another bill that came through concerning mental health issues relates to that commission that I told you about at the beginning, called the Deeds Commission, or the SJ 47 Commission. That's been a legislative commission that gets reestablished every single year. And so there was legislation this year to make it a permanent behavioral health commission. And that did pass, and it was signed by the governor. We were disappointed in it in a way. I think it's important that there be a constant attention on behavioral health needs in the Commonwealth, but we were disappointed that they were not willing to allow mental health consumers to be part of this commission. And we were hopeful that the governor might amend that Behavioral Health Commission to include consumers on that, but the governor did not. And we know now that mental health advocates are already seeking legislation to fix that in the next session. So hopefully we will have a more recognized voice of mental health consumers on that commission going forward. Those were the biggies on the mental health front. Any questions on any of them?
There are questions in the chat.
Okay, go for it.
Well, Valerie asked a question and then Rhonda answered it. So she said, why such a long delay on the bill? And Rhonda said, the delayed enactment date gives the system the opportunity to develop processes and procedures for the new law, and also lets it work things out.
Right, right. So thanks for that question, Valerie. This is a tactic when a patron of a bill, when they're pushing something they really, really want to get through, and it's starting to run into trouble with the details. Often a patron will put what's called a delayed enactment on it. We're going to get it through this year, but we can come back next year if we need to and fix it before it actually takes effect. And so that's what was happening with the mandatory outpatient treatment bill, is that practitioners out there were starting to point out how many problems there were in the proposal that Delegate Hope had. He was really committed to get it through. And so he put a delayed enactment on it and promised that he would work with parties to resolve the difficulties that were identified. Another question, Courtney?
Deja asked, can you explain more about the ability to comply with the treatment?
The ability to comply with the mandatory outpatient treatment order? Is that the question?
Explain more about the ability to comply.
Yeah, I was trying to figure out what is the difference between agreeing to treatment and complying.
So in our perspective, it's a huge difference because of the possibility of it lasting beyond the order. If somebody has bought into the treatment plan, if they agree to the treatment plan, there's a much greater chance that they will actually stick with it for the long term. Somebody can, so for example, the treatment could be that you have to take a medication on a daily basis. So you may have the physical ability to swallow a pill, but may not want to because of the side effects of that pill. You may not want to because of, it gives you weight gain, that it impairs your energy for life. There may be reasons why you don't want to take it. You still have the physical ability to take that pill. If you don't agree with that treatment plan, as soon as that order is over, you're going to stop complying with it. And so the long-term efficacy of that treatment plan is gone. Does that make sense?
Yeah, that makes sense.
Yeah, so we think it makes all the difference in whether mandatory outpatient treatment is actually successful or not, whether someone is buying into it, whether they're agreeing with the plan.
Thank you.
Sure. Any other questions, Courtney? And if you're responding to me, you're on mute.
I think she's.
I don't see any more questions, but I'm just calling in on my phone right now.
Oh, okay. Okay.
This is breaking.
Okay. Yeah, it's breaking.
Colleen, this is Harry. I've got
Hi, Harry.
A question on the Deeds Commission. What kinds of groups are mandated on the commission, since they're leaving out consumers?
Only legislators. There's a designated number of senators, a designated number of delegates. There will be no, there's not even members of the executive branch who will be on it. They will serve as consultants to that. And if they follow past practice on the Deeds Commission, they will permit consumers to give public testimony at hearings and to maybe assist with work groups. But honestly, we've been to those meetings, and by the time they get to the public testimony, they're not paying attention anymore. They've moved on to something else. And it's really a very, I think, very disrespectful process for people with mental health issues.
And they're not considering allowing any providers
Correct.
Of services either.
Correct.
Nor CSBs or
correct.
Anybody else.
They have, in their past practice, they have called on the community services boards to sort of serve as experts on particular issues. And when they do that, they pay attention to them. But no, they will not be members of this, and will otherwise be relegated to public testimony.
Thank you.
Sure. Anything else before we move on to the next really controversial topic? So I'm going to turn over to Jenny now, who's going to tell you about some subject matter that really got controversial, and she'll tell you how happy we were or were not with the result.
Thank you. This is my first year really doing special education legislation down at the General Assembly. So it was a learning for me, and very fun too, to kind of hear about all the different perspectives. But one of the legislative things that we monitored this year was legislation seeking to alter the Children's Services Act, which we call CSA. And CSA has all these different funding streams. Basically, the funding stream that the legislation talked about this year concerned that the CSA funds only went to private. So you're funding a private school placement for a child with a disability. This year, we saw bills coming out that really sought to put it back in public schools as well. The bills came from a report from the Joint Legislative Audit and Review Commission, which we call JLARC, which had a ton of findings, but among those findings, the ones that were really prevalent to the bills were that we were seeing really increased rates of private school enrollment. And within that, restricting the funds to only private schools, the CSA funds only being allowed there, we're seeing really high levels of institutionalization and usage of private segregated day settings for our clients. And so with that, and this was one of the hot topics I think that Colleen mentioned, but dLCV does acknowledge that some children may benefit from private school settings. We totally understand that. But at the same time, we would really like to see a continuum of services afforded to our children. So, more resources in the public schools, meaning maybe they don't have to go to private school placements. So both the House and Senate put forward a ton of different bills on this issue, and some of them enacted, 6 or 7 points from the JLARC study. Some only did 1, and there was a ton of kind of collaboration across legislators and stakeholders and families and parents and groups like dLCV. We tried to really work with our stakeholder groups on these issues too, to really amplify our client and parent voices as well. In the end, one of the primary bills that passed regarding this was from Senator Mason, and it encompassed a lot of the other bills too. So what does that bill do? It allows the funds to be used in public schools and programs, only those that are licensed by the Virginia Department of Education. It also allows those funds to be used for transition services. So for kids coming back to public school however, it is notable that those transition services have a cap. They could only be used for 12 months of transition services. And that was another hot piece too, because people really wanted to see those transition funds allowed, further, maybe not for transition, but after transition, so that the child can stay in that public school setting. We sadly lost that one as well. And so the cap is in the current bill that passed. So where do we kind of look ahead from that? it's important for dLCV to be involved in the work groups that are responsible for developing a plan for how this is going to go and for implementing it in the community. Because we know from our work, our casework and our systems work, that the way that CSA works is very, very different from locality to locality. So we really want to be a part of that. We would also advocate for a pilot program. Senator Suderline put forward legislation that talked about implementing a pilot program to kind of see how it's going in the Roanoke, Southwest Virginia area. Sadly, that failed to pass, but it doesn't mean that it can't go forward, moving forward. And then lastly, we would really argue for the funds to be used past that 12-month cap that I mentioned previously, because we want kids to be able to access that continuum of services. So in summary, I think we believe that this legislation really allows for public schools to increase their resources and expand their programs, which would ultimately allow kids to stay in their locality and safe to home, close to home, and also in the least restrictive environment. So I think it's really exciting legislation, and hopefully it's going to continue in the next session too. Right. Are there any questions for me on that one? I know that was fast and furious.
So with it, we saw a little bit of forward motion on that issue, not anywhere near what we would have hoped for. But we also kind of felt like legislators were expressing general support with the concept of adequate funding for kids with complex behavioral needs in particular. These are usually kids with severe autism. These are kids whose the public schools really are generally not doing a great job of supporting them. We would like for those kids to be able to stay in their home schools, but the public schools have a ways to go before they are going to be in a position to really fully support kids to stay at home. So some forward motion, more work to do. Do we have any other questions? I'm not seeing any hands up or anything in the chat box. Okay. So, I mentioned that one of the tactics that a legislator can use when their bill starts to get into trouble is to put a delayed enactment clause on it. But the most common tactic that a legislator will use when a bill starts to get into trouble is to convert it into a study. So, if they're taking on an issue and they're getting a whole lot of pushback from people, they'll just convert it into something that the legislature is going to study for a year instead. So there are a number of those, and Ron is going to give you a little rundown of the bills that got either converted to be studies or started out as studies. Take it away.
Thank you. So there's a lot of them, and I'm going to just give a little bit on each one that we're going to be monitoring. There was a lot of discussion in this session about the needs of older adults. And a couple of the studies, there was 2 studies coming from the Joint Commission on Healthcare. One on the impact of the long-term care workforce needs on nursing facility care. So this has been an issue for a long time that people have identified. And so the Joint Commission on Healthcare, which is a joint commission with legislators from both houses, and it's currently chaired by Delegate Patrick Hope. This particular study, it's designed to look at the extent to which there are staffing shortages in nursing facilities in Virginia and understand what the causes of those are, evaluate the impact of those shortages on the quality of care, which is a huge concern for many people, families, individuals, and advocates, and look at sort of how our current licensing requirements and oversight appropriately identify and address quality of care issues. There was a bill that went through this session that did not pass that would have addressed this issue, and also identify strategies to improve recruitment and retention of the workforce. And this has only gotten worse with COVID. I mean, we hear from nursing facilities talking about they have trouble keeping staff and whatnot. So it's this huge problem. Also, the Joint Commission on Healthcare is going to do a study that will develop strategies to support aging Virginians and their communities. So, the staff are going to need to identify, what the necessary continuum of services and supports are that would keep people in their homes and communities to keep them out of institutional settings. Evaluate whether the current state and local programs are, effectively coordinated. Look at, the root causes and the variation of, community supports across the state, which is a big problem. Well-resourced communities like, in Northern Virginia, for example, have a greater ability to offer services and supports than, counties downstate in Southside Virginia or in Southwest Virginia. And then identify effective programs in Virginia and other states that could potentially be implemented either, expanded in Virginia or implemented here in Virginia. And then a similar work group, it's not a study so much, but as a work group, the Department of Behavioral Health and Developmental Services is in budget language. There was a budget amendment that was a language only amendment requiring DBHDS to evaluate, along with the Department of Aging and Rehabilitative Services, to look at the needs of individuals with dementia in state hospitals. And some of these are older adults, some of them are not older adults, but they have dementia or related conditions. And some of these folks are, stay in the state hospitals for years because there really aren't any sources in the community. So one of the things that this work group is going to look at, what the state and make recommendations for what the state could do to divert people with dementia from the state hospitals and discharge those that are in the state hospitals with dementia. And one of the things that they're going to look at in particular, and there was a special language amendment for this, is that the work group will evaluate the Northern Virginia Regional Older Adult Facilities Mental Health Support Team, which is called RAFT for short. And this is a pretty well managed and considered program in Northern Virginia that provides support to older adults with serious mental illnesses, basically. And they want to look at that program to determine if it would be feasible to replicate that in other places around the state. So those are some studies that are relating to older adults. One that's sort of related resulted from House Bill 2053, which was introduced by Delegate Ibrahim Samira. And this directs the Department of Housing and Community Development to convene a stakeholder work group to look at the issue of attached and accessory dwelling units as a strategy to address our growing need for affordable and market rate housing. And so, this is not specific to disability, to folks with disabilities, but could potentially impact folks with disabilities. So I don't think we're going to be a stakeholder on that group, but we're definitely going to be monitoring the work of the group. And then Jenny and Colleen both earlier referred to JLARC, the Joint Commission on Joint Legislative Audit and Review Commission. And so this is a really important study that we're going to be monitoring. They are going to study the court-appointed guardian and conservator system in the state and look at some specific things like looking at current laws that help prevent and remedy the abuse, neglect, and exploitation of older adults and people that are incapacitated who have guardians. Examine some opportunities to strengthen the laws to prevent and remedy this kind of abuse, neglect, and exploitation. Identify the appropriate training, qualification, and oversight requirements that court-appointed guardians should have. Look at the kind of information that they should have when they make decisions on behalf of their ward, and identify, parties who should receive this information, and really review the adequacy of oversight of the guardian and conservator system, which, I think many of us have been concerned about for quite a while now. I think that was all of the studies that we're going to be monitoring for the coming year. Colleen and Jenny, did I leave anything out of that list? I think that was all the ones that we're going to be watching.
Well, and I'll turn that.
Yes, I apologize. There's one more.
Okay.
Senate Bill 1304, which was introduced by Senator McPike, required DBHDS to develop a discharge planning work group to review the current process for discharging folks from the state hospitals, state psychiatric hospitals, You know, this is a big piece of work that dLCV does, is provide advocacy to folks in the state hospitals related to discharge and discharge readiness. The DBHDS maintains an extraordinary barriers to discharge list, which includes people that are clinically ready to return home, but the service or support or the housing that they need to successfully discharge is not available in the community. And, you know, we've been monitoring this data since about 2014, when the department really kind of started to keep track of this data. And the CSBs have been a somewhat of a barrier to this process. So Senator McPike included in the bill that DBHDS wants the CSBs to get more involved in more timely discharge, to develop some timeliness mechanisms so that people can get out on a more timely basis. And so the work group needs to report its findings and conclusions back to the chairs of the Senate Education and Health Committee and the Health, Welfare and Institutions Committee in the House of Delegates by September 1st. So I think those were all of them.
Any questions for Rhonda about the work groups and studies? The bill that she described about the discharge planning work group is a good example of a bill that started out in one form and then morphed into something different. When the bill was being drafted, what it was going to do was give the Department of Behavioral Health responsibility for discharge planning, because the department felt like the CSBs were just not stepping up quickly enough to it, that the hospital would be the one that would develop the discharge plan, and then the CSB could modify it after somebody's been out. By the time the bill finally got filed in the legislature in late December, that was changed again. And instead what it said is that somebody can be discharged from the hospital without a discharge plan, and that the CSB would then have 30 days to develop a discharge plan post discharge. So, you know, you kind of understood where the department was coming from, that they were expressing frustration with how the process was working. And, you know, we're always beating up on them on keeping people in the hospital past the time that they really belong there. But this sort of felt like the worst possible solution, to just let somebody out of the hospital with no plan. And I think that as it worked its way through the legislature, the department started to see that this was just not a good solution. So this is a bill that did morph into a study group, into a work group. And as it did so, dLCV made it clear that we want to be at the table on this. And we've told the CSBs that we think that a lot of the problem with the discharge is with them, and we want to be at the table to share our experiences. And as I'm looking down at the list of the people who are on this call, a couple of you need to know you're going to be our pick to be on that work group. So heads up on that one. And just so you know, Rhonda, we've been working on this issue long before 2014.
Oh, absolutely, yeah. I think that was when the department started actually tracking the EBL data. So
yeah, we filed a lawsuit against the department in 2004, I think it was, to get the list of everybody who had been held 30 days past the time that they're ready for discharge. So we've been trying to solve this problem for a long, long time, and have not really come up with a good solution yet.
I have a question. You said that they have 30 days to come up with a discharge plan before the patient goes out of the hospital. Oh, no. After the patient dies. But who is the institution in charge of considering or planning or find out where the patient will be living if it's dementia, their diagnosis? I know we think that the support of the family and they should be coming back to the community. But many of those people have been so far away from their family that honestly, no one wants to deal with them. And that is why they are for so long in those institutions. So,
thanks, Yeah, so that's a lot. That's actually two slightly separate issues there. And you're exactly right that community services for people with dementia are pretty limited. And this is one of the things that the study is going to be looking at, is what the options are other than state hospitals. The thing that we know is that the state hospitals are not well equipped to serve somebody who has dementia. So for the most part, people are ending up in locked wards with no freedom because the state hospitals really do not know a good way of a good model to serve people with dementia. Some people with dementia will be able to move to adequately supported community services. As with any kind of disability, there's a whole range of ways in which people respond to that disability. Some people will be more able to maneuver in the community than other people. But right now there's nothing. So that is one of the things that Rhonda mentioned that they will be studying, is other better options for people with dementia. The bill about the discharge planning is a little bit different. It's not specifically about people with dementia. It's about people with mental illness who are no longer at that heightened need to be in a hospital.
Oh, I see. Okay.
So, and just let's be really clear. One of the proposals was that people could be discharged without a plan, and that did not pass. That is not the solution they came up with. What they did come up with was a work group to study what the obstacles are to discharge and ways that we can get over those obstacles. So, in some ways, I think that the department was putting that proposal out there to kind of be provocative, to catch everybody's attention and just say, this is a problem and we can't solve it by ourselves. So hopefully bringing people to the table to talk about it will enable us to get to some solutions for it.
Hey, Colleen, we have two hands raised. Harry's hand is up, and so is Michael's.
Okay, let's hear from our guest, Harry, before we turn to staff, Michael.
Hi, so is there any need or appetite to have a similar work group on discharge planning for people with physical disabilities as compared to mental or behavioral disabilities to ensure that there's appropriate resources out there? I mean, just offhand, someone goes in without a wheelchair and comes out with a wheelchair or something right along that line. Requiring payers, for instance, to pay for ramps or things along those lines? Is that something that is worth pursuing?
I don't know whether our work would constitute a study or not, but we have been trying to track patterns of the obstacles to people being discharged. And so we will absolutely bring to this work group what our experience is. And I don't know if there's anyone on the phone, Rhonda, whether you know if lack of assistive technology, durable medical equipment, anything like that, whether that ends up being a barrier to discharge, accessible housing options, if those ends up being barriers to discharge very often.
I don't know that physical disabilities or the needs of people with physical disabilities is something that, that might fall into sort of an other barrier kind of category that they don't specifically track. But I think it's more really probably the majority of the people on the list, their barrier is housing. That's one of the biggest issues, and
supportive housing, not just a house.
Yeah, exactly.
But someplace where they can go, where they're going to get the supports that they need to maintain their treatment.
Yeah, and the problem really there is that, we are over relying on congregate settings like nursing homes and assisted living facilities for folks in this population, which, by and large, they're just not really appropriate. So that's a big issue.
Right.
I could think also about someone who lives alone and then has to come home, and what kind of barriers, supports need to be put in place,
right,
outside of going to a congregate setting.
Right, right. Yep. Yeah, those will be things that we will hopefully have a chance to address in the work group.
I think Harry brings up an excellent point too regarding children's discharge services and needs, because that is often a barrier, looking at children's physical needs and then also medical needs as well, such as like diabetes diagnoses and things like that, which are really lacking in the community. And that results in kind of on the opposite end, like Rhonda was talking about nursing home overuse. You have ID and then DD facilities that are overused for kids, as well as psychiatric residential treatment facilities. And so bringing the kids' perspective too, with what Harry is mentioning, I think will be also very important.
Right. Let's hear from Michael, and then let's talk about some of the bills where we really rocked it out the park this year. Michael?
Hey, there we go. I've been concerned about this discharge planning thing for a couple of years because like you said, back around 2004, we made a lot of advancements in discharge planning. I remember when we were making a press release about establishing a right to a written discharge plan, for example.
Right.
But over the last couple of years, this no plan business, or at least no written plan, has become not only commonplace, but it seems to be the norm. There was a requirement at one time that discharge planning began when a person went into the hospital, continued all the way through. There's a written plan on record somewhere. I just finished a complex discharge of a person with multiple disabilities. So you would expect a big discharge plan. There was never any written discharge plan at all from either the CSB or the facility. There was a lot of horse trading back and forth, and they managed to get the person out promptly once we got involved. But and they made the necessary arrangements, and we reviewed all that, and it was good. But the fact is, there was never anything in writing, and that was really disturbing to me to see that just disappear like that.
Right. Right.
And then, of course, one other point is this business with the CSBs being the problem. As the system stands, they have an economic incentive to keep people in the hospital. They are paid under their performance contract, certain amount. And when the person's in the hospital, they're not having to pay to supervise them, case manage them, et cetera. There's been proposals that we change the performance contract and then how that works, and then charge them for the time that people are in the hospitals instead of what we're doing now. I'm not sure why that hasn't ever been seriously considered by the powers that be. So anyway, I'm very hopeful for this discharge planning. I think it's definitely one of the ripest issues we got. And it's not just the ready for discharge list, it's the whole planning process seems to have just fallen apart in the last couple of years.
Right, right, right.
I mean, I do think that the issue is really not going to go away until we address the community housing problem. Because really when people don't have a place to go, they're stuck, and so I think it'll be interesting to see how the department, given that so much of the barrier is about appropriate housing and just as little as we want to see people going to nursing or assisted living, when that's the recommendation at discharge, and no nursing homes don't want to accept people from psychiatric hospitals. I mean, I think that's a huge problem that we need to address, and nobody's really talking about it. So hopefully this, we'll discuss it, and the discussion will get back to the new Behavioral Health Commission so that they can start dealing with housing issues.
Okay, so we're not going to be able to belabor this particular topic too much.
Sorry.
We've got a couple more minutes here, and want to tell you about, there were 3 different issues that the Disability Law Center brought to the legislature and asked for some solutions, and we were able to get good solutions on all 3 issues. One of them deals with a technique for voting known as curbside voting. Our current law says that somebody who has a disability or is over age 65 can vote from their car. They can approach the polling place and vote from their car. But it doesn't go any further than that. And the way a lot of polling places operate that is that they say you have to come inside and ask for that ballot, which, you know, is one of those like not clear on the concept kind of things. We found that somewhere around 35% of polling places in our survey don't have any kind of indication for somebody how they would get a curbside ballot. So this legislation just simply says that the polling places have to post information about how to ask for that ballot. We've seen some places where they put a cell phone number. Some places have designated parking spots where somebody can park and wait for the ballot, and then they have somebody who is monitoring the door to see if that spot is taken. One of the districts, one of the towns told us that they have high school pages, high school interns who work on election day, and their sole purpose is to watch to see if somebody needs a curbside ballot. So there's lots of ways to solve this problem. Many polling places just simply did not want to, and now they don't have a choice. So this is something, House Bill 1921 is legislation that we pushed through, and it got passed and has been signed by the governor and will take effect July 1. Another really, really big piece for us has to do with the state's Human Rights Act, which prohibits discrimination in employment and housing and education and public accommodations. The law was changed last year, a year ago, to add protections against discrimination for the LGBTQ community. And when it was changed, the law neglected to include people with disabilities in the long list of protections when it came to employment. People with disabilities were protected against discrimination in public accommodations, in housing, in education, but when on the employment provisions, they dropped the protections against people with disabilities. So we were able to get that fixed. Delegate Mark Sickles sponsored House Bill 1848. It went through with just like no opposition whatsoever, which is remarkable because last year when the protections were added for the LGBTQ community, the business community, the chambers of commerce, manufacturing associations, those organizations all came out in strong opposition. But when we fixed it for people with disabilities, there was just no opposition. So we kind of pitched it as correcting a typographical error, but in fact, this law is huge. It brings Virginia into line with the language and the protections of the Americans with Disabilities Act, except that it now covers any size employer. The Americans with Disabilities Act covers employers with 15 or more employees. Virginia's Human Rights Act covers any size employer. So it's really a huge expansion of protection for people with disabilities. And it also updates the language in the Virginians with Disabilities Act, which had really outdated stuff in it. And that's really important as we are looking at a United States Supreme Court that may be very unfriendly towards federal human rights legislation. And so we are worried that the new composition of the Supreme Court may start to gut some civil rights legislation like the Americans with Disabilities Act. And in Virginia, at least, we now have those protections in state law. So gives us a little bit of comfort against what might be a darker day for civil rights enforcement. And then the final piece of legislation that we got through this year has to do with abuse and neglect reports that are required to be filed by everybody who is licensed by the Department of Behavioral Health and Developmental Services. Department of Behavioral Health licenses more than 2,000 providers. Every one of those providers has to notify the department when there's been an allegation of abuse and neglect. They have 10 days to do an investigation and submit their findings. And once they have done that, the Disability Law Center of Virginia gets access to every single one of those reports. It's a little mind-blowing for us right now. We are going to have more information than we really know what to do with. We are in the process of acquiring a database for these reports where we're going to hope to be able to track trends, look for patterns of things that if we can address the pattern, might be able to save many, many more people than if we address them one at a time. But it's an enormous responsibility for us, and we're both delighted and terrified by it. So before we do a quick little wrap up here, any other questions? Any hands up? Anything in the chat box? So just to let you know, a couple of things. We are, essentially starting to work on the 2022 session. And we're doing that mostly at this point by shoring up the relationships that we've created with some good legislators, hoping that they will be favorably inclined to work with us on stuff going forward. And, on the 3 bills where we had this year, we had really good relationships. And the one Jenny worked on with Delegate Tran, really good relationships with the legislators, and think that they'll be in a position to help us with issues as we go forward. We made an attempt this year to invite volunteers to help us in the legislative process, and we didn't do a great job of that this year. We really were trying to figure out how to manage a virtual session on our own, and really didn't figure out a good way to employ the skills of volunteers in that process. So we will be trying to get together with some volunteers and get their feedback on how we might be able to do a better job of that going forward. Jenny, Rhonda, any other wrap up comments for the good of the whole here? Anybody have any other questions for us before we sign off?
I have a quick one. With the Virginia Human Rights Act, has there been any, if I understand that correctly, it doesn't bind state agencies, state facilities, anything like that. Has there been any move to address that?
I do believe actually that the State Human Rights Act does bind the state as an employer.
Yeah, as an employer, but I'm talking about like in services, parallel to the ADA.
Similar to Title II, similar to Title II. Mm-hmm. I don't think it does. So that would be an interesting thing for us to look at. Because yes, that would be one of the things under the ADA. If the ADA were to be under attack, that would be one of the things that would be likely to go.
Thanks.
Yeah. All right, any final questions? If you're waving your hand, I can't see it. Then I actually thought, Michael, you were waving goodbye. So, all right, if there's no final questions, then thanks so much for joining us, and stay tuned for the 2022 session, which is getting closer all the time. Bye-bye, everybody.